Friends, have you ever found yourselves tangled in a legal spiderweb, a situation so absurd it feels like a bad sitcom? Well, buckle up, because today we're diving headfirst into the wild world of resolving legal disputes without the hefty price tag, and often the equally hefty drama of hiring a lawyer. Prepare to be amazed, amused, and maybe even slightly terrified by the realities of navigating the legal system solo. You might even spit out your coffee when you hear some of these stories. Let's face it, lawyers are expensive. Their hourly rates can make your eyes water, and the bills can pile up faster than you can say objection. But before you throw your hands up in despair and accept whatever fate throws your way, know this: many minor disputes can be resolved without the need for expensive legal representation. We're talking about everything from neighborly squabbles over fence lines to minor contract disagreements. The key is knowing your rights, understanding the process, and employing a healthy dose of strategic patience and wit. Documentation is your best friend. Think of yourself as a meticulous detective, meticulously gathering evidence. This includes emails, contracts, photos, videos, anything that supports your claim. I once heard of a case where a dispute over a damaged rental property was settled entirely based on a series of exceptionally well-documented photos showing the pre-existing damage. The judge, bless his soul, apparently appreciated the photographic evidence far more than the heated arguments presented by the involved parties. It was truly a masterclass in photographic legal prowess. Next, communication is key. Before you even think about escalating the situation, try to resolve the issue directly with the other party. A calm, rational conversation, focusing on the facts and avoiding emotional outbursts, can often work wonders. Remember, the goal isn't to win a battle. It's to find a resolution that works for everyone involved. Unless, of course, the other party is a particularly unreasonable neighbor who insists their prize-winning petunias are the sole reason for your garden's alleged blight. In such cases, well, we'll discuss alternative strategies. Mediation is another fantastic option, especially for disputes involving multiple parties or complex issues. A neutral third party helps facilitate communication and guide you towards a mutually agreeable solution. Think of it as a professional referee for your legal disagreements, ensuring the game stays fair and within the rules. I once witnessed a mediation session where the parties were initially so entrenched in their positions they seemed ready to declare war. But by the end, they were sharing cookies and discussing their shared love for obscure 80s sitcoms. Truly, the power of mediation is astonishing. If mediation fails, you might consider arbitration. This is a more formal process where a neutral arbitrator hears evidence and makes a binding decision. It's less expensive and less time-consuming than a court trial, but it still involves a level of formality that might require some preparation. I recall one arbitration case where the arbitrator, a former judge with an apparent penchant for puns, managed to keep both parties engaged and amused throughout the proceedings. Apparently, his closing remarks were a masterpiece of legal wit, leaving both parties chuckling despite the gravity of the situation. It goes to show, even the most serious proceedings can have their lighter moments. Now let's talk about small claims court. This is your last resort before engaging in full-scale legal warfare. It's designed for relatively simple disputes involving smaller amounts of money. The process is generally straightforward, and you're not required to have a lawyer. However, it's crucial to prepare thoroughly, present your case clearly and concisely, and remain calm and respectful throughout the proceedings. I've seen cases where seemingly simple disputes escalated into full-blown theatrical productions, with dramatic pauses, whispered asides, and even impromptu interpretive dance. It was truly a spectacle, though not necessarily one I'd recommend repeating. Before you even consider small claims court, however, remember the importance of pretrial discovery. This is the process of gathering information and evidence from the opposing party. While it sounds intimidating, it's often easier than you think. Simple requests for documents or information can be surprisingly effective, and you might be surprised by what you uncover. You might even uncover evidence that completely changes the narrative of the entire dispute. I once heard of a case where a seemingly straightforward breach of contract dispute revealed a secret underground society of competitive vegetable growers. It was unbelievable. Remember, though, even in small claims court, a little preparation goes a long way. Knowing the rules, understanding the process, and presenting your case clearly and concisely can significantly increase your chances of a favorable outcome. And remember, even if you don't win, the The experience itself can be a valuable learning opportunity. You might even find yourself developing a surprising talent for courtroom theatrics. Beyond the specifics of these methods, there's a broader strategy to consider: understanding the psychology of conflict resolution. Often the most effective approach isn't about winning, but about finding a mutually acceptable solution. Empathy, clear communication, and a willingness to compromise can go a long way in resolving disputes peacefully. Think about it. Is winning a small claims case really worth the time, stress, and emotional toll if it damages a relationship or creates lasting animosity? Many disputes stem from misunderstandings or miscommunications. Taking the time to truly understand the other party's perspective, even if you don't agree with it, can help you find common ground. This is where active listening comes in. Truly hearing what the other person is saying, rather than just waiting for your turn to speak, can lead to surprisingly productive conversations. You might even find that the other party is just as eager to resolve the issue as you are. Remember those seemingly endless arguments over property lines? A simple, friendly chat might reveal that the trespassing was simply a misunderstanding, a case of misaligned survey markers, or even a shared love for a particularly aggressive variety of ivy. The point is, many times, conflict resolution is less about legal technicalities and more about human interaction. And sometimes, a little bit of humor can go a long way in diffusing a tense situation. Let's not forget the power of a well-written letter. A formal yet polite letter outlining your concerns and proposed solutions can be surprisingly effective. It provides a clear record of your communication and allows the other party time to consider your position without the pressure of an immediate confrontation. It's like a carefully crafted diplomatic message, delivered with the grace and precision of a seasoned ambassador. And who knows, it might just avoid a full-blown diplomatic incident. Finally, remember that navigating legal disputes without a lawyer requires patience, persistence, and a healthy dose of self-reliance. It's not always easy, but it is often rewarding. You'll learn valuable skills in communication, negotiation, and problem-solving, skills that will serve you well in many aspects of life. And who knows, you might even develop a hidden talent for legal maneuvering, a talent that will leave you wondering why you ever considered hiring a lawyer in the first place. So go forth, armed with your knowledge, your documents, and your sense of humor. The world of legal self-representation awaits. And remember, even if things don't go exactly as planned, the stories you'll tell later will be epic. Absolutely epic.